much as a scholar of constitutional populism or scholar of constitutional law, but as someone who has attempted to study the rule of law developments within a country and as a part of the judicial anti-corruption campaigns. And that's how I met Dragoș, which is I had the opportunity to interview him for the purposes of developing my doctoral dissertation. And that's how I learned more about the struggle that the judicial associations in Romania are waging against the limitations to the judicial independence that have happened in the past decade in Romania. And that's how I learned more about the judicial branch of government in Romania. Basically, so I'm coming to this topic from that sense. I have also learned very much from Bianca Selejan-Gutan, which is why I'm very happy to have her also today speaking with me and sharing the virtual floor with me, in particular with her contributions to the edited volumes that were prepared by Martin Bello, but also by the posts, as you have said, Giuseppe, that were published on the Verfassungsblog. I fortunately have had no opportunity until now to interview her and to perhaps obtain her feedback. So I'm coming to this. We're coming to this situation of the rule of law crisis in Romania. I have put a question mark here because not everybody's calling it a rule of law crisis, because some people doubt and state that basically what we're having here is somewhat different. And there are two main reasons why it appears, why some people contest the notion that whether what has happened in Romania lately with the relationship between the Romanian Constitutional Court and the EU and the Court of Justice of the EU on the one hand, and then on the other hand with the relationship that the various governments have developed towards the judicial branch of government is or is not a rule of law crisis. So people say, well, you know, if you look at the rule of law crisis in Poland and in Hungary, then we're speaking about really a political project that is led more or less by one political actor. And those political actors are also usually trying to develop some sort of a constitutional or a legal theory that supports their notions for the expansion of the ideas of, for example, constitutional identity, and in order to challenge the primacy of EU law, whereas with Romania, this doesn't seem to be the case so much. And then second characteristic is really that it seems to be more or less in Romania, there seems to be a certain consensus with the political actors. Perhaps not all of them, but a large group of them, not just the PSD party, which you could say started the backlash against the judicial anti-corruption campaigns. That basically there needs to be a stronger control, a stronger oversight over the judiciary as such, which is why the SIOJ. The special investigative offices to investigate the judiciary and crimes committed by the judiciary were very slowly dismantled. I'll come to this point later, which were very slowly dismantled. And even this dismantling has raised many negative commentaries from the judicial associations, but also from the Venice Commission. And so whether the judicial anti-corruption campaign can be considered a source of the crisis, the narrative about the judicial anti-corruption campaigns are basically the events that have happened between 2010 and 2017. In short, when the National Anti-Corruption Directorate prosecuted a large number of cases of political and bureaucratic corruption. To those of you joining us today from Italy, this whole period was compared, and I compare it also in my dissertation, to the so-called Mani Pulite operation of the 1990s. Because it had a heroic prosecutor figure in the face of Laura Codruta Kövesi. It had a huge media coverage. It was a spectacular legal event and a spectacular political event. And there was an important role that the EU has played in designing the judicial anti-corruption campaign, insofar that following the general consensus that the country, Romania, is unprepared to join the EU designed the so-called cooperation verification mechanism, which was in effect a monitoring mechanism designed to check whether the country is progressing primarily on its rule of law obligations. And these obligations involved linked strongly rule of law and the fight against corruption in one sentence. Since Romania took this very seriously, and its political class at the time took it seriously, what happened was not only the creation of this National Anti-Corruption Directorate. Institutions like this have been created everywhere, pretty much across Eastern Europe. The problem was that the Romanian, well, not the problem, one of the reasons for the success was that the Romanian DNA had very ambitious prosecutors, had a young cadre, and had basically strong connections and cooperations with the SRI, which was the Romanian intelligence agency, which had the mandate and the authority to conduct investigations and to do wiretapping and so-called special investigative measures, which have resulted in great successes in terms of numbers of people prosecuted, but also great worries for those who believe that the rights of the accused were violated, and that the real rule of law violations were not the ones conducted by the political class, exploiting corrupt opportunities to undermine, which were undermining the rule of law and democracy as such, but rather by those who were investigating the such occurrences. And this gave rise to a narrative, which was also very present in Italy and also present in Brazil during the Lava Jato operation, to this narrative of the secret power, which is the invisible hand which actually governs Romania with the foreign support. And what happened once PSD took over from 2016 onwards was basically a change in the approach that the legislative and also that the legislative branch of government and that the constitutional court had towards these operations. So basically, what started from 2016 onwards was a gradual dismantling of first the not just the judicial independence, but the very opportunity to fight corruption. And indeed, this is just a side note, one of the main impacts that the operation had was actually that the judicial branch of government now is much less in a position to fight corruption than it was 12 years ago, speaking from the institutional standpoint. And which is why I say that the RCC, the Romanian Constitutional Court, in a way joined the fight against corruption. And some people commenting on this have called this Tănăescu, I believe, who was also called this basically a case of populism on the part of the Constitutional Court itself, because there was a string of cases in which the court used its doctrine of constitutional conflicts between the various branches of government to basically dismantle the opportunities to involve the SRI, which was the intelligence agency, into investigation, and then to limit the role that the president at the time, Iohannis, had in his opportunity to influence who holds the position of the main special prosecutor in Romania. And then also the Constitutional Court reviewed criminal legislation related to instances of abuse of office, which are these two cases, 405, 2016, and 392, in which the court basically seriously limited the opportunity for the prosecutors to exploit the abuse of office, which led really gradually to the shrinking of space for prosecution. And in this sense, we could say surely that the Romanian Constitutional Court acted as if there was a need to react to a judicial revolution, a disbalance in which one branch of government, the judicial branch of government, was too independent and basically encroaching on governing itself and doing what you could call prosecutorial overreach. So coming from this, then they started the government at the time, but also you could say the court starts facing opposition, which comes from the judicial associations, which start launching their own requests for preliminary procedures, which were sent to the CGEU, and the RCC itself was offered here an opportunity for a judicial dialogue when its own decisions and requests to review the constitutionality of the creation of the section for the investigation of offenses committed within the judiciary, which was, we could say, the last straw that really mobilized the judiciary in its action against such measures when this decision was reached. So in decision 137 of 2019, the court, the Romanian MPs who launched this procedure for constitutional review explicitly stated that the questions that this question should be based, that the Constitutional Court should refer this question to the Court of Justice of the EU, precisely because they expected that the questions of national constitutional identity will arise once this is being reviewed. And unfortunately, the Romanian Constitutional Court here, despite, when you look at the stances and writings of some of the judges, for example, Judge Attila Varga, he explicitly previously, when writing about this case, he said, well, this is an opportunity for a judicial dialogue, but that's not really what happened in that moment, because the court didn't really, at least from what I have seen, and I'm looking forward to your comments on this, didn't really go far in defining national constitutional identity. Essentially, in my opinion, they have a, you could say, put an they basically state that national constitutional identity is whatever are the essential state functions, and essential state functions are what is the national constitutional identity. So they defined it too broad, which also advocate generals have commented in various of their opinions. And then they have also seen the CVM, the Cooperation Verification Mechanism, as not a source of the European law, but rather a source for monitoring reports, which are non-binding and non-important. And in a landmark judgment of May 18, 2021, to which the Romanian judicial associations have contributed so much, and should be proud of, the CGU found that the CVM is a valid source of law. And basically, with this, many have, on the other hand, criticized this. For example, Kochanos has said, well, we could have reached this conclusion in a very different way. We shouldn't have necessarily went for defending the CVM at all costs. Now, perhaps, okay, Giuseppe will now probably heavily criticize me, but maybe this was an opportunity also for the CGU to defend, to see a sort of a value in the CVM as a policy tool, but also to avoid every single opportunity to necessarily try to mark whether or not, and to what extent actually, are we speaking here of an essential state function, and to what extent the design of the judiciary should be considered a part of the national constitutional identity. And the RCC, to its stance, has released a press release after that, finding that the CGU has basically okay, this is a strong formulation, has acted ultra vires in its judgment, but then has also taken a step forward, which is why many people have become nervous, because the RCC rejected the possibility that a judge may challenge the norms found constitutional by the RCC, and thereby really severed the connection that a national judge should have towards the Luxembourg court, because it really and that was the moment when the RCC actually started drawing clear boundaries over what can really be part of the constitutional identity. And this, in a way, it made sense, but it was really too broad, and then leading to these other problems and cases which were resolved in the judgment 430/21, where the CGU ruled that the judge cannot be prevented from and put at risk of disciplinary proceedings and penalties as a consequence of examining the conformity of a certain regulation with the EU law. And then any failure of a judge to comply with this international does not necessarily trigger their disciplinary liability, which was also received somewhat different, in a very complicated way and manner, in a way which is sort of difficult to discern if you're looking at the situation as an outsider, because it didn't really, the current government wasn't really in the position to necessarily defend everything that the court has done. So there was, I think, not so much view that this is a European project to govern Romania by foreign force, but also it was not received so much with the enthusiasm. It has done a lot really to prevent, on the one hand, this opportunity, this attempt to sever the connections of the judges to the Luxembourg court. But then on the other hand, it created a problem, because effectively it created a great problem for the section for investigation of the offenses of the judiciary, because and the other disciplinary bodies, because it limited the opportunity to now to establish disciplinary proceedings within the judiciary. And which is why I expect also that we will hear from our other speakers something about the next steps, which politically the laws governing the dismantling of the SIOJ were to be adopted under the legislative plan of the government by March 31st. They have actually been adopted even earlier, and we know this from the Venice Commission report, because they have heavily criticized what they saw as a hastened procedure, and what they saw as an opportunity to really reconstruct the whole system of the judicial independence in Romania, and particularly with regards to the responsibilities of the judges. So it still leaves open ground for an open series of questions where legally the Romanian Judges Association still might have maneuver to challenge these decisions, maybe in front of a forum. And then also, whatever happens, while of course my sympathies are not so much with the RCC, still it's really important in at least for us, people who study corruption and the rule of law issues that come out from the corruption, is what really will the Romanian Constitutional Court do now? Not just to further the concept of constitutional identity, but also with its practice that has been heavily criticized. And where will they take the gain forward, defining the concept of constitutional identity, or maybe going now towards more judicial dialogue with the Luxembourg court? So that's from me for now.
Thanks indeed, Nedim.